Welcome back, AP Government people, to video number 38, key terms associated with the judicial branch and the Supreme Court. All right, let's start off with some key Latin terms that you should know. Stare decisis says that let means let the decision stand. In other words, using precedent in earlier cases to help reach a decision on another case. So if there is a case before a court and it's similar to another one, chances are the court will rule the way it did on that previous case. Amicus curiae means friends of the court, and this allows interest groups to write letters to the court detailing how a decision would impact them. So they kind of give their opinion on, hey, this is what would happen if you rule this way. This is how it would affect us. Writs of certiorari, I am terrible at pronouncing that. I definitely just butchered that. That is when the Supreme Court orders a case from a lower court to be reviewed. So they may go to the appellate court, for instance, and say, yo, pass your stuff up. We're taking a look at this. We want to review it. And remember, Rule of 4 says 4 judges agree to hear it. That case is being heard. Restraint and activism are two terms you must know. So start both of these bad boys. Judicial restraint is the belief that the Supreme Court should rely on precedent in making decisions. So this is more of a conservative approach, and this favors less court involvement. Judicial activism is kind of on the opposite end of that spectrum. It's the belief that the Supreme Court can correct injustices. So, for example, Brown versus Board of Education overturned Plessy versus Ferguson. The Supreme Court was not restraining itself in that. They were very active in correcting injustices. The doctrine of original intent means that you are looking at the Constitution based on the intention of the framers. So trying to figure out how would the framers decide this. The incorporation doctrine, we're going to have a whole video on this bad boy later, but definitely know this. This is applying most of the Bill of Rights to state governments. For example, Mapp versus Ohio with search and seizure. And this is done through the 14th Amendment. Again, I promise we'll have a video soon on it. It's wicked, wicked, wicked important. The Rule of 4, as I mentioned, if 4 justices agree, that Supreme Court is going to hear that case. Majority opinion, this is how most of the Supreme Court decides a case, and this becomes law. And this is written by one of the justices, usually the highest ranking justice that agrees with the majority of the court. On the opposite end of that spectrum, we have the minority opinion, and this is written by a dissenting justice explaining why the justice disagrees. Now, final slide of terms, Judiciary Act of 1789. This established 6 justices for the Supreme Court, including a Chief Justice. And then we'll have 9 in the latter 19th century, the latter half of the 19th century. This also established lower courts, those that we have today. The Solicitor General, this person is the one who argues in front of the Supreme Court on behalf of the government, helps influence which cases the Supreme Court hears. And they are in charge of appeals for the U.S. government. All right, guys, look forward to see you back here for video 39, divided government. You see what I did there with a little division symbol, huh? Don't worry, there's no math in there. Thanks for watching. Best of luck this year, and have a good day.